It's absolutely my honor to introduce Professor Stanley Paulson from Keele University and St. Louis University. I'm very proud that you are delivered the lecture, so it was absolutely for us wonderful, I would say, even not exaggerate, beautiful occasion to listen. One of the most prominent philosophy of law in Europe and in all over the world. It's not exaggeration, of course. Thank you very much, Stanley, for being with us, and so the floor is yours. Thank you very much.
I want to begin by thanking Mark Smolak warmly for the invitation, and more generally, I want to thank all of you in the law faculty for the invitation. Bonnie and I are very happy to be here, and I believe it's my fourth or fifth time in Poznan, and I'm pleased to be able to say that. There are several professional engagements, and we've also been present at the internationally celebrated violin competition every 5 years, as you of course know, in your fair city, and we've been at that event twice around. Thanks to all of you for coming. I want to offer you a chapter, or maybe a chapter and a half, that underscore the audacity of Hans Kelsen. I should add that I don't come to you as a Kelsenian. I don't think there are many Kelsenians out there, that is, genuine followers of Hans Kelsen in a very serious and committed sense. I have met a few in Vienna. That's to be expected, but precious few elsewhere. Kelsen was indeed an audacious legal philosopher. If we think of norm theory, for example, Kelsen in the mid-1930s arrived at an altogether new view on norm theory. The empowerment is the fundamental normative modality, a significant move on Kelsen's part because it represented success in his long-time effort to escape the connotations of the old imperative theory. Kelsen is an audacious legal theory in rejecting both fact-based legal positivism and natural law theory. Kelsen, in effect, said, a pox on both your houses. And Kelsen theorized as a non-naturalistic positivist, and that is the explanation of his long-time engagement with Kant, the Kant of the first critique, as distinct from the Kant of moral philosophy. My example today of Kelsen's audacity, the end of traditional legal interpretation, or something close to that, something close to the end of traditional legal interpretation, and that by design in Kelsen's case. And I think the audacity of Kelsen's work is at least a part of the explanation for the extraordinary interest in Kelsen around the world. In your country, you know these things better than I, but I know some of the names. In fact, Bonnie and I, many years ago, met Wroblewski in Łódź, and we met Opałek in Krakow. Though I did not have the honor of meeting Professor Jambinski, I do know something about his reputation. Happily for me, there are a handful of pieces in English which I know. In my adopted language, as distinct from my mother tongue, Kelsen is a fascinosum, an object of fascination. Relatively few real followers in the narrow sense of the word, but a great many admirers. I think of Robert Alexei, my colleague and friend and host in Kiel, an admirer, but by no means a follower. And that stands in sharp contrast, I would think, to the case of Herbert Hart, H.L.A. Hart. Hart has many, many followers. In fact, a colleague and friend of mine in Genoa said not all that long ago, Stanley, you know, it's a wonderful thing that Hart breathed new life into legal philosophy in the Anglophone world, which of course he did, but it's a pity, my friend in Genoa added, that 50 years later people are still talking about little else than Hart's theory. Aren't there other things to do besides talking about Hart as special as he was? Hart has his followers, Kelsen his critics. One thinks, for example, of Joseph Raz as a critic of Kelsen's. One thinks of Eugenio Bulligan in Buenos Aires, and that's, of course, just the beginning of a long list. I'd like to divide my talk today into 4 parts. Part 1 is introductory. I'll try to set the stage with a bit of talk about the 2 theses that I want to adumbrate and then argue on behalf of 2 species of law in Kelsen. That's not generally known, but I think it's there, and I'll try to explain why I think it's there. And then this talk of mine about the end of traditional legal interpretation in Kelsen. That's the introduction. Then the second part, a quick tour through Kelsen's skeptical remarks respecting traditional legal interpretation, various canons and strategies of traditional legal interpretation are dismissed by our friend Hansa Kelsen, and the question arises why, and more pointedly, to whom was this skepticism of Kelsen's directed? Part 3 then has me talking about the second species of law. I'll back up just for a moment. The first species of law, the law qua as an ideal object of legal cognition. Ideal, the adjective is important there. This first species of law is traceable back to critical idealism, stemming from Kant and the Kantian figures of the later 19th century. That's the first species of law, I repeat. Law qua ideal object of legal cognition. And it finds itself in a separate sphere that is separate from our natural world. And the other species of law is what you would expect, the law qua acts of will, the law qua politics, and that has us back on the planet in the natural world that we know. Query, why 2 species of law? And I'll say a bit about that if time permits. And I want also in the 4th and last part to at least invite attention to what I see as a dilemma for Hansa Kelsen on this front. So to begin at the beginning, 2 species of law, I've mentioned them, and my task, of course, is to try to say something about why there are indeed 2 species. I might comment briefly on each of the species of law. The first, I repeat, the law qua ideal object of legal cognition. Not generally well known in Kelsen research, not generally well known in the secondary literature on Kelsen. Why not? Because people by and large do not take the role of Kant in Kelsen's theory all that seriously for, I guess, a variety of reasons. But I think it's there, and I think it has to be there. If you consider Kelsen's stance vis-a-vis the traditional views, fact-based legal positivism, rejected by Kelsen, natural law theory in all its forms, rejected by Hansa Kelsen. And then the question arises, well, what's left? Has he not mousetrapped himself? No. Kelsen is quick to answer. There's Kant, the Kant now of the first critique, and there's a distant but interesting historical analogy. The Hegelian historians of philosophy in the 19th century and into the early 20th century talked about rationalism and empiricism as having been seen in the 17th and 18th centuries, not only mutually exclusive, that's very obvious, but also seen then as together exhaustive of the possibilities. And then Kant gives the lie to that view of the nature of the beast. Kant offers us something entirely new, and there's an analogy there, perhaps only a distant analogy, to Kelsen's work. So one explanation for the lack of attention to this first species of law is the fact that the Kantian dimension of Kelsen has not received the attention it deserves. What about the second of my theses? The first thesis, two species of law. The second thesis, the end of traditional legal interpretation, or something close to it. That may strike some of you as a dubious thesis, not to say an outrageous thesis. How can he possibly be talking along those lines? But Kelsen did reject the canons and strategies of traditional legal interpretation, and that's fairly clear in Chapter 6 of the first edition of the Pure Theory of Law, and Chapter 8 of the second edition of the Pure Theory of Law. And the question arises, why? And I think there, at least a good part of the answer stems from Kelsen's purity thesis. The purity thesis rules out, on the one hand, value judgments, everything evaluative, and on the other hand, appeals to matters of fact, appeals to the social sciences, and it's not controversial to say that interpretation involves inevitably and unavoidably evaluations, value judgments. And if that's so, then Kelsen's purity thesis rules out that material. The question arises, of course, what are the legal scholars, what are those of us in this room to do without any guidelines on legal interpretation? That, I think, is a good question and is a part of the dilemma I want to pose at the end.
Pandora is just making crazy.
Thank you, Martin. My point of departure takes me to a quotation on the first page of my paper. Some of you may have that paper in front of you or in your computer. I'm toward the bottom of page 1 in the paper. This is a quotation from the first edition of Kelsen's Pure Theory of Law, the edition that Bonnie and I translated some years ago. And it's a fairly good statement of the two species of law. Better statement of the first species than of the second species, but not bad on the second species either. I might quote this statement: the law, qua ideal subject matter, is a system and therefore an object of juridical normative cognition. Cognition is really the central focus of this first species of law. Juridical, or here, juridical normative cognition. And then he turns to the second species of law, while the law qua act, think of acts of will, the law qua act, both motivated and motivating, both psychological and physical, is power, legal power, and is, as such, an object of inquiry for social psychology or sociology. But one wants to add, and I do add, not solely an object of inquiry for the social sciences. There's a bona fide legal dimension. The political actors, we know them, the legislators, the judges, the administrative officials, are empowered to give voice to the acts of will that are then transformed, the Kantian filter, I call it, into legal norms. So we have two species of law. That quotation gives you at least a hint of what's going on with each species of law. And I'd like to take up then briefly the first of the two species of law. And here I have interesting quotations in the manuscript at page 12. At page 12 in the manuscript, there's a long quotation. I'll not read the whole quotation. I'll simply invite your attention to a couple of points in this long quotation from the 1953 edition of the Pure Theory of Law, which Kelsen revised based on the first edition way back in 1934, and this 1953 edition was published in French and is not well known. Page 12, if I go down to the fourth line of the quotation and then substitute for the language there, the character of legal norms, substitute for that language acts of will, my substitution in the fourth line, acts of will set out by the lawmakers, and now the quotation, as having the character of legal norms, are legal norms only if they are recognized, or more precisely, cognized by legal science. End of quote. And then at the end of this quotation, the very end, last full line, Kelsen contrasts natural cognition, which we know from Kant, with what he has called the juridico-normative cognition. And you can see the distinctly Kantian flavor there. Natural phenomena, the object of the causal sciences, are created by the causal sciences in a purely epistemological sense. That quotation then on the first of the two species of law. Cognition of general legal norms yields then, in the hands of the legal scholar, a range of individual legal norms, or, putting the same point just a bit differently, the legal scholar now establishes the various readings of the general legal norm. Might imagine, with a fairly general norm, a broad spectrum of possible readings. Query, how does the legal scholar arrive at this spectrum of possible readings of the general norm? And to take that point just a step further and to invite attention to another passage in the paper, I believe this is page 7 or 8. Yes, on page 7, the quotation toward the bottom of the page, Kelsen says in that quotation that the legal scholar arrives at, second line, the possible meanings, the range of possible readings of the general legal norm, and then penultimate line, and these readings then are set out for the legal authorities, the judges, who then choose on political grounds, one reading or another. And that is useful in establishing Kelsen's sharp distinction, at some points at any rate, between the legal scholar and her enterprise on the one hand, and the legal authority and his enterprise on the other. The latter, the judge, the administrative official, the legislator, is a political actor, and her work reflects the second species of law. The legal scholar, by contrast, is engaged in what Kelsen sometimes calls legal cognition, or here, normative juridical cognition. And that enterprise is found in the first species of law. Another way of putting the point, and this language may be familiar to you, it's familiar at any rate in the German language literature, the political actors, legislators, judges, administrative officials are engaged in what's called authentic legal interpretation. They're making law. Authentic legal interpretation is longhand, not shorthand, longhand for their making law. And the legal scholar, she, sitting in her office, arrives at this set of readings of the general legal norm. Her work is non-authentic interpretation, and that makes sense when you consider that she is not, and does not purport to be, making law. So much for an overview, just a hint about what I'm up to here. I want very briefly in part 2 of my talk today to turn to Kelsen's skepticism regarding the traditional canons and strategies of legal interpretation. Here, as I've mentioned, and as many of you know, he is a skeptic, rejecting out of hand these canons and species of legal interpretation on the ground that they are, without exception, question-begging. It is very interesting that Kelsen, at this juncture, second species of law, does not look all that different from the old-style American legal realists. And the most skeptical of those people were prepared to say, you think this judge is a bona fide intentionalist and he's really concerned about what the lawmakers meant, what they intended in drafting and passing this statute? Ladies and gentlemen, it's a put-on. The judge is doing that for the sake of appearances, makes it all look respectable, but in fact, the judge is deciding on political grounds. American legal realists and their counterparts in the European free law movement were saying those things 100 years ago. And in fact, it's of great interest to me anyway, wearing my historian's hat, to see how close Hansa Kelsen and Hermanna Kantorowicza on this front were. In fact, I exaggerate only a bit when I tell you that some of Kelsen's arguments look very much like Kantorowicza's, as though he were copying out of Kantorowicza's text. I don't go that far, and there's no reason to go that far. But the similarities are striking. The similarities are striking. Many critics dismiss Kelsen as a formalist. Formalism is, in juridical philosophical circles, a nasty expression. Means of rejecting the entire theory out of hand. And as you know, Kelsen was called a formalist by not least of all the Weimar critics, and I have a long footnote with 2 examples of Weimar critics of Kelsen's ostensible formalism. The first of them, Hermann Heller, is a fairly respectable statement. The second, from Rudolf Sment, is anything but respectable. Sment, in this quotation, writing 5 years after the end of World War II, associates in his diatribe Hansa Kelsen of all people, with the concentration camp that Sment and his friends found themselves trapped in. You imagine saying that in 1950 about Hansa Kelsen, who was in the spring of 1933 quite literally running from Hitler, and yet Sment was prepared to write such things. And the question arises, I've had discussions with Bonnie and with our friend Robert Alexei on this issue. Why did they hate him so? Why did they hate him so? And I don't have any very helpful answer. That's the stage. Kelsen's younger colleague Fritz Schreier wrote a book in 1927 on interpretation, a very skeptical stance on interpretation, reflecting Kelsen's own stance. Kelsen, 2 years later, speaks to that monograph and indicates that he, Kelsen, is prepared to endorse the views of Hermanna Kantorowicza, who way back in 1906 had written in a Schmähschrift, a kind of little polemical tract, the struggle for legal science, der Kampf um die Rechtswissenschaft, and he, Kantorowicza, at that point in time, was prepared to overthrow virtually everything in the European jurisprudential tradition, which made him, of course, very unpopular in professorial circles. And Kelsen, in the first edition of the Pure Theory of Law, 1934, was not far removed from what Kantorowicza was saying nearly 30 years earlier. 4 rubrics are worth mentioning in this connection. The first of them, will versus expression, intention versus text. And some of you know a good bit about the debates in my country, originalism, intentionalism on the one hand, textualism on the other, both species of originalism versus, for example, Ronald Dworkin at the other end of the spectrum, and then a variety of views in between. An early monograph by John Hart Ely is important on this front. I mentioned that development simply to bring things up to date. Kelsen said no basis for choosing between intention and the text. And there is a quotation to that effect on page 15 of my manuscript, and I invite your attention to it. Quote on page 15, the first of the indented quotes from the standpoint of the positive law. It is a matter of complete indifference whether one neglects the text in order to stick to the legislator's presumed will, or strictly observes the text in order to avoid concerning oneself with the legislator's, in parentheses, usually problematic, will. No basis, he says, for adjudicating that dispute. He's the skeptic. The second set of issues, analogy versus argumentum a contrario, same thing. You're begging the question, if you insist, that the one takes priority over the other. Fictions, the third category that Kelsen, like Kantorowicza, talks about in this book. Kelsen is notorious for his view here, there are no fictions. There are no gaps, I beg your pardon. And his explanation for that view, there are no gaps, lies once again with his skepticism. If you spoke of gaps in the law, you're then engaged in fictions in trying to fill these gaps. And once again, the fancy language of the lawyers and judges is little more than a vast put-on. They're simply giving expression to their preferred political views. And Kelsen says, we'll have none of it. He argues that there are no gaps because the lack of a position in favor of the plaintiff, this simply means that the defendant prevails, and that too is a legal position. Fourthly, and we can bring this one up to date as well by referring to Robert Alexi's work, the balancing of interests. In those days, at least in Germany, the balancing issues were developed by the so-called Tübingen school. Philipp Heck and his people today, as many of you know, Robert Alexi has responded to critics, no less a figure, for example, than Jürgen Habermas, who expressed his, Habermas's skepticism about balancing these decisions ostensibly based on a balance are arbitrary and capricious, and Alexi has gone to some lengths to try to show that at least in some cases, one can assign, for good reasons, greater weight to the one side than to the other. And as I say, some of you know that. Kelsen, again, the skeptic, don't believe a word of this balancing talk. It's all of it question-begging. Enough then on Kelsen's skepticism, a short tour through that part of chapter 6 in the first edition of the Pure Theory of Law. I want to go on now, and I'm trying to keep track of the time as well so that I don't rattle on for too long. Next section of my talk, the second species of law. The second species of law. And here I'd like to set out very briefly three considerations that together make a case on behalf of the second species of law, the law qua politics, the law qua acts of will, and the first of the three species has me talking about an anecdotal account. It's in your text. The anecdotal account takes us back to 1931, the exchange between Kelsen and Carl Schmitt toward the end of the Weimar Republic. An interesting exchange, as you can imagine, and I'll come back to it in just a moment. The second rubric, acts of will, taken, as you, if you will, on the merits, and the third rubric, the legal dimension of the political actors, namely empowerment. And there we have a wonderful development to report on. I'm almost tempted to say a new development. In fact, this development of Kelsen's on empowerment goes back to the mid-1930s. But few people knew about it until the paper in question was published many years later, the end of the 80s. And once it was published, one saw that Kelsen had changed his mind dramatically on norm theory, such that, as I said at the outset, empowerment is now seen as the fundamental normative modality. And then once you appreciate that, all sorts of other things in Kelsen's texts take on a significance that they didn't have earlier, because now you see them in the light of this development on empowerment. For example, his talk about the ought, das sollen, as akin to a variable expression. People didn't make much of that in the old days, although it's there in the 1945 volume General Theory of Law and State, there in some papers from the 1940s and 50s, there in the second edition of the Pure Theory of Law. It takes on an altogether new significance once that talk is seen in the light of this shift of Kelsen's to empowerment. And I will come back to that. First, however, the anecdotal account, and all three rubrics have me making a case for this second species of law. The end of the Weimar Republic, background, a reserve constitution as early as the summer of 1930. That is, the Chancellor, Brüning, is unable to reach an agreement with the Parliament on a budget. What does Brüning do? Rather than negotiating further with the Social Democrats, who had proved to be recalcitrant, he turns at this point to the President of the Republic, Hindenburg, with the request that Hindenburg prepare the way for a budget by appeal to the emergency powers of Article 48 of the Weimar Constitution, although, of course, there was no emergency to talk about. Hindenburg issues the emergency decree on the 16th of July, 1930. On the 18th of July, 2 days later, the Social Democrats in the Parliament rescind the emergency decree. Hindenburg responds to that by dissolving the Parliament with elections, it's understood, within the next 60 days. And after the dissolution of the Parliament, the emergency decree is then reissued by Hindenburg. The Social Democrats are no longer there to do anything about it. This establishes a pattern. Emergency decree without an emergency, and the provisions of Article 48 are fairly clear what constitutes an emergency. Rescission by the Parliament, dismissal of the Parliament by the Reich President, and then the reissuance of the emergency decree, this time without any danger of the Social Democrats getting in the way. This is the so-called reserve constitution or presidential system that was defended by Carl Schmitt. Kelsen, for his part, defended constitutional review, and as you know, Kelsen was a major figure in the drafting of the Austrian Federal Constitution of October 1920, and in particular, Kelsen gave voice to the provisions for constitutional review, and of course, that's an institutional practice that was picked up all over in Europe in the post-World War II period. You don't need me on that one. Schmitt argues that in the statutory context, and by the way, the buzzword here, the buzzword is decisionism, associated with Schmitt. And Schmitt argues that in the statutory context, decisionism can be handled, can be controlled, because the statutory context proceeds by way of subsumption, isn't likely then to get out of hand. But, Schmitt argues, and now he's addressing Kelsen and Kelsen's position. Schmitt argues that constitutional context is altogether different. There, the lawmakers, the constitutional court judges, are not constrained by anything remotely like subsumption, and the result is a political tribunal, so Schmitt. Kelsen agrees. The most interesting development here, Kelsen agrees with Carl Schmitt about decisionism. That is a fact of life in lawmaking, decisionism. The decision is brought to the content of the statutory provision that's now being applied, rather than somehow stemming therefrom. Kelsen agrees, I repeat, with Schmitt on the general point about decisionism. It's there and can't be wished away. But he then goes on to stand Schmitt's argument on its head. Kelsen says all forms of law are political in character. Therefore, it's not a problem that constitutional adjudication is also political in character. That was Kelsen's response to Carl Schmitt. That's the anecdotal case, and if it were simply a history of their exchange involving polemics, it wouldn't be appropriate to talk about here. But in fact, my suggestion is this anecdotal account reflects the second species of law, the law qua politics, the law qua acts of will. And that takes me to the second of these mini rubrics within the third part of my talk. And I'm at page 23 in my manuscript. the very top of the page. The quotation is not indented there. I beg your pardon, it starts at the very bottom of page 22. Bottom of page 22, Kelsen writes that there is no question of a logical deduction of legal norms from a basic norm, or for that matter, from anything else. And then he continues, and now I have the quotation, legal norms must be created by means of a special act of issuing or setting them. And now the punchline, an act not of intellect, but of will. Acts of will on the part of the political players, judges, legislators, administrative officials. These figures, and this is as important here as it is obvious, so I may be allowed to invite attention to it. These figures, the men and women who serve us as legislators, as judges, as administrative officials, are flesh and blood men and women. That stands in contrast to the situation with the first species of law, which is ideal in character. The so-called persons found in the first species of law are simply personifications of clusters of legal norms. Clusters of legal norms. And we know something about legal persons from such institutions as corporations, of course. And the state itself, Kelsen sees as a complex cluster of legal norms. That is enough said then on the second mini rubric. We must have a second species of law, lest we not be in a position to talk about the men and the women who serve us as legislators, as judges, as administrative officials. So there you have it, this second species of law. Finally, the third mini rubric of the third part of the talk, and we're making reasonably good progress in terms of the time. I invite attention to page 25 in the manuscript. There we have these extraordinary statements. First, the mid-1930s, and then a couple of statements from the second edition of the Pure Theory of Law. And these statements talk about empowerment. And the point for my present purposes is that we can call this second species of law because the political players out there on the stage are legally empowered, such that if what they issue as an act of will is done properly and the ordinary course of events is followed, then it makes its way through the Kantian filter and emerges as a legal norm. And the last full line of the first quotation on 25 is something I want to invite your attention to. This whole quotation is a part of the long reply to George Sell in the mid-1930s. And the last full line reads, the legal obligation of the one individual rests on the sanction imposing competence of the other. And then we have clearer statements of that, owing to a further development on Kelsen's part, in the second edition of the Pure Theory of Law. That takes me to the middle indented quotation on page 25. And there I'd like to quote for you the whole thing. If a delict specified by the legal system is committed, then a sanction specified by the legal system ought to be imposed. Here the term ought covers both the case in which the official is only empowered to impose the sanction and the case in which he or she is commanded to do so. And then the question arises, and I have that in my text here, well, what about it? In which cases do we have merely the modality of empowerment at work, and in which cases do we have the modality of the command, the modality, if you will, of obligation? And he answers that, and I'll explain this, in the last of the indented quotations on page 25. I might quote again, the imposition of the sanction is commanded, is the content of a legal obligation if its omission is made the condition for a sanction. Where this is not the case, the official can be taken to be only empowered to impose the sanction, not commanded, not obligated. And you can think of the structure here by imagining adjacent tiers, adjacent levels in what Kelsen, as you know, calls the Stufenbau. Stufen is German for levels, Bau is German for construction. A construction of levels, and the Stufenbau is, of course, the legal system for those in the Vienna school, not least of all in this connection, Adolf Julius Merkel, from whom Kelsen drew the Stufenbau doctrine. So let's think of a legal official A. He or she stands at the lower level in the hierarchy. A legal official A is empowered to impose a certain sanction on the legal subject, never mind the details. And if a legal official B at the next higher level is empowered to impose a certain sanction on A, should A fail to impose the sanction on the legal subject, then Kelsen says we're in a position to say that A is obligated to impose the sanction. Thus, obligation is created in Kelsen's conceptual framework from a pairing of empowerments on adjacent levels of the Stufenbau, or hierarchical construction, Kelsen's legal system. The significance, and the significance is great, cannot be overestimated. This characterization of obligation in terms of empowerment, a characterization of obligation in conceptual terms, means that Kelsen, this is Kelsen now, not Stanley Paulson, that Kelsen has succeeded in escaping from the connotations of the old imperative theory, from the connotations of moral theory, a problem from his standpoint, from the beginning. And I might give you a quotation here because it underscores this point so nicely from section 11b of the first edition of the Pure Theory of Law, without a doubt the most important subsection 11b of this little treatise. And I quote here, "The judgment that something is legally regulated, that some norm content is obligatory owing to the law, is never entirely free of the notion that for this to be so is good, right, and just, moral notions. And in this sense, the conceptual characterization of the law as norm and as ought, offered by the positivist tradition of the 19th century, does in fact retain, as Kelsen puts it, a certain ideological element." And then he goes on, one more line, "The pure theory of law seeks to free the conceptual characterization of the law from this ideological element." This book is written in 1934, and just a year or two later, in the reply to George Sell, he has managed to free the law, he would have you believe, from the moral, or if you will, ideological connotations that have plagued everyone's work, his included, from the beginning. I'm not going to pursue The dilemma, my fourth part, owing to the constraints of time, I will mention, however, the dilemma. It seems to me that the legal scholar in Kelsen's work is left in a rather difficult position. Legal cognition tracking Kant is not going to work for the legal scholar. That would have the legal scholar receiving data from without, so to speak, in the way that Kant has us receiving data from without, owing to the faculty of sensibility. And in fact, John Mackey, a colleague of H.L.A. Hart's, philosopher, over a long period of time, invented something called normative space to try to make a case for an analogy, just as Kant talks about space and time as the so-called pure forms of intuition, so likewise Kelsen talks about normative space, and normative space has the legal scholar receiving these data, acts of will. But then where does it go from there? The acts of will are drawn through the Kantian filter, and in the ordinary course of events, then they emerge as general legal norms. And now the task of the legal scholar is to, as I mentioned at the outset, provide this spectrum of readings that stem from the general legal norm. How is normative space, as an analogy to Kant's faculty of sensibility, going to help here? The general legal norm is, of course, a reflection of niceties, politics, concerns in a particular jurisdiction at a particular point in time. None of that can be drawn from a Kantian filter. And it would be wildly implausible to suggest that it could. But the other point of the dilemma, Kelsen seems to have ruled out the traditional canons and strategies of legal interpretation. And the question arises, what's left? What now? And that's the dilemma I pose for our friend Hansa Kelsen in the last part of my paper. I thank you very much. Many thanks. Many thanks.
Once again, thank you very much to be in Poland.
I thank all of you for coming. Many thanks.
Thank you.